Hi, good evening, sir. No, I have to unmute. Nitin, unmute ಮಾಡ್ದಾ?
Yes. ಆಗಿದೆ.
Okay. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸುತ್ತಿರುವ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರ ಮುಖ್ಯ ಪರೀಕ್ಷೆಯ ಅಂತರ್ಜಾಲ ತರಬೇತಿ ಶಿಬಿರಕ್ಕೆ ತಮಗೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಇಂದಿನ ಉಪನ್ಯಾಸಕರಾಗಿ ನಿವೃತ್ತ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರಾದ ಶ್ರೀ SR ಸೋಮಶೇಖರ್ ಇವರು ಆಗಮಿಸಿದ್ದಾರೆ. ಇವರಿಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ಸ್ವಾಗತ ಬಯಸುತ್ತಿದ್ದೇನೆ. ಇಂದಿನ ವಿಷಯ ಆಸ್ತಿ ವರ್ಗಾವಣೆ ಕಾಯ್ದೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್. ಎಲ್ಲ ಅಭ್ಯರ್ಥಿಗಳಿಗೂ ಶುಭ ಕೋರುತ್ತಾ ಉಪನ್ಯಾಸಕರಾದ ಶ್ರೀ SR ಸೋಮಶೇಖರ್ ಅವರನ್ನು ಇಂದಿನ ಉಪನ್ಯಾಸ ನೀಡಲು ಕೋರುತ್ತಿದ್ದೇನೆ.
Can it be a mixture of English and Kannada?
Yes, sir. That's what the students want.
Okay, sir. Please. Good evening, Shri Baswaraj, and good evening, friends. Though on a few occasions the Bar Council had invited me to speak on a few subjects, and Advocates Academy, of which Mr. Ambedkar is the leader, had invited me on a few occasions to speak to the advocates who had taken up examination. This is the first time I am speaking on the platform of the Law Academy. I'm extremely glad. You are able to hear me, sir?
To move back, ಸ್ವಲ್ಪ ಹಿಂದೆ ಹೋದ್ರೆ ನಿತಿನ್ ಸ್ವಲ್ಪ ಹಿಂದೆ ask. Yes, sir. Yes, sir. Perfect.
You are able to hear me, sir? No.
Yes, sir. Perfect.
I'm extremely happy that the Bar Council has also started this Law Academy. When as the principal district judge in Bangalore Rural District, I received a letter from the Bar Council saying that the principal district judges also have something to do with the Law Academy as far as the districts are concerned. And at the High Court level, the Registrar General has to coordinate and monitor. Anyway, it has come through now, and I am glad to associate myself with the Law Academy. Now I must start my presentation with a word of apology. I have some personal work for the last 8 to 10 days. I am busy with my son's marriage, and I did not prepare myself deeply into the subject. Well, I'll be speaking on a few aspects or a few concepts only of the Transfer of Property Act. The subject is a little tough and it is vast. It may be difficult to cover it within a span of 2 years. Two things I would like to take into account. One, my primary concern is to help the advocates as far as their profession is concerned. Incidentally, if my presentation helps them in getting through the examination, well, nothing beyond that. Because results of the examination are not in our hands. It depends on the performance of the candidates. Well, I don't think that by such lectures only they can get through the examination. They will have to prepare themselves very intensively and extensively also, because they are taking up the district judges examination. If my presentation today helps them in any way in the profession, I think my object is met. this Transfer of Property Act has mainly two parts. ಇಲ್ಲಿ ಎರಡು ಭಾಗಗಳಿವೆ ಇದು. The first part deals with general principles of transfer. Of course, the first few sections, definitions and other things, leaving that. Commencing from section 5 to 53A, it deals with general principles. ಯಾವುದನ್ನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಹುದು, ಟ್ರಾನ್ಸ್ಫರ್ನ ಎಫೆಕ್ಟ್ ಏನು, ಯಾರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಹುದು, ಏನನ್ನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಹುದು ಅಂತಕ್ಕಂಥ ಜನರಲ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಕೆಲವು ಹೇಳುತ್ತೆ. ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಡೀಲ್ಸ್ ವಿತ್ ಸ್ಪೆಸಿಫಿಕ್ ಟ್ರಾನ್ಸ್ಫರ್ಸ್. ನಮ್ಮ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದ್ದ ಹಾಗೆ ಸೆಕ್ಷನ್ಸ್ 1 to 75 ಜನರಲ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್, ಆಮೇಲೆ ಸ್ಪೆಸಿಫಿಕ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಹೇಳ್ಕೊಡ್ತಾರೆ. ಇಂಡಮ್ನಿಟಿ ಅಂಡ್ ಗ್ಯಾರಂಟಿ, ಬೇಲ್ಮೆಂಟ್, ಏಜೆನ್ಸಿ, then sale of goods, partnership, negotiable instruments. Similarly, under the Transfer of Property Act, up to 53A, we have general principles. Thereafter, it deals with specific transfers: sale, mortgage, lease, gift, exchange, and actionable claims. All of you know it. As I said in the beginning, I will take a few topics and explain to you the concepts which may be of some use to you. I am not giving a historical background of the enactment. Any book on the Transfer of Property Act, more particularly Mullah's TP Act, will give you that. We will straight away take up a few definitions which are of which may be of importance not only in view of your profession, but also in view of the examination. Though normally the bulk of civil litigation in our courts relates to immobile property, it may be of some information to the uninitiated that the Transfer of Property Act deals with transfer of mobiles also, though the provisions in that regard are a few and far between. Most of the provisions relate to transfer of immobile properties. Let us confine our discussion to the principles relating to transfer of immobile properties and the various kinds of transfers contemplated by the Act. Having said that it also deals with mobile property, I must tell you what a mobile property is. The Act does not define mobile property. It defines immobile property, and therefore what is left out is mobile property. ಸ್ಥಿರ ಸ್ವತ್ತನ್ನು ಮಾತ್ರ ಇಲ್ಲಿ ಡಿಫೈನ್ ಮಾಡಿದ್ದಾರೆ. ಚರಸೊತ್ತು ಅಂದ್ರೆ ಏನು ಅಂತ ಹೇಳಿಲ್ಲ. ಆದ್ರಿಂದ ಸ್ಥಿರ ಸ್ವತ್ತಿನಲ್ಲಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರದೇ ಇರತಕ್ಕಂಥದ್ದು ಚರಸೊತ್ತು ಅಂತ ನಾವು ಭಾವನೆ ಮಾಡಬೇಕಾಗುತ್ತೆ. Go to section 3. In this act, unless there is something repugnant in the subject or context, immobile property does not include standing timber, growing crops or grass. It is not an inclusive definition. It's a kind of exclusive definition. It says it doesn't include certain things. Standing timber, ನಿಂತಿರ್ತಕ್ಕಂಥ ಮರ, ಗ್ರೋಯಿಂಗ್ ಕ್ರಾಪ್ಸ್, ಬೆಳೀತಾ ಇರ್ತಕ್ಕಂಥ ಬೆಳೆಗಳು, ಗ್ರಾಸ್ ಫುಲ್, ಇವು ಬಿಟ್ಟು ಇದು ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ಆಗುತ್ತೆ ವಿನ ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಹೇಳುತ್ತೆ. One definition is important, and that is more particularly in the context of practitioners. Go to the definition of the word attested. Attested in relation to an instrument means, and shall be deemed always to have meant, attested by two or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument. I stop here. A problem usually arises in the court. The plaintiff says that the defendant executed on a sale agreement in his favor, so and so attested the documents. Of course, an agreement of sale does not require attestation. There is a different thing. Now, what the defendant has put on the document is his thumb mark and not a signature. PW2 is the attesting witness. He comes and tells that on a particular day, the plaintiff called him over phone to come to the office of an advocate or the sub-registrar, where the defendant was present, and he and another witness were also present. some transaction took place. It was agreed that the defendant should sell the property to the plaintiff for a consideration of about 30 lakhs. Plaintiff paid 10 lakhs as advance. Thereafter, the defendant executed an agreement of sale and affixed his LTM. It may be a gift deed also. PW2 may give evidence in the same fashion. When it comes to the marking of this thumb mark, either the court raises an objection or the defendant raises an objection. Is the objection sustainable is my question. Let us read the definition again. Attested in relation to an instrument means and shall be deemed always to have meant attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument. PW2, the attesting witness, says that he saw the defendant affixing his mark to the instrument. He gives direct evidence of it. I do not think that in law there could be any valid objection for marking this thumb mark because he is a witness who has seen the defendant affix his mark to the instrument. In fact, under the Indian Evidence Act, we have what is known as opinion evidence regarding handwriting and signature, covered by Section 47 of the Evidence Act. I am familiar with the signature and handwriting of my father. My father is not alive. Let us assume that my father executed some document during his lifetime. I was not present when he executed the document. I cannot give direct evidence of the execution of the document. I can give opinion evidence under Section 47 regarding his signature or regarding his handwriting. Many times the attesting witness is dead. His son or daughter comes to the witness box and identifies the signature of his son or father. To this extent, it is opinion evidence. But when it comes to opinion evidence regarding thumb mark, it is difficult. So please bear this distinction. Direct evidence regarding thumb mark is not at all prohibited in the plain meaning, the definition of the word attested, whereas opinion evidence is prohibited. Therefore, if the objection is that so-and-so is giving opinion evidence, in my opinion, it is the LTM of my father, sister. No. I was present when he affixed. Certainly, that evidence can go on record. You will find a repetition of these words in Section 63 of the Indian Succession Act, also dealing with attestation of wills. And as all of you know, under law, 3 documents require attestation. 1, will under the Indian Succession Act. 2, mortgage under the Transfer of Property Act. 3, gift under the Transfer of Property Act. Unless it is attested by 2 witnesses, it is no document in the eye of law. And of course, I may have to slightly deviate in the interest of the candidates who have taken up examination and also who are very keen in the profession. I am quite conscious of the fact that I am not called upon to speak to you about the Evidence Act. But incidentally, it may be of relevance to tell you that under Section 68 of the Evidence Act, if a document requires attestation in law, its execution can be proved only by calling at least 1 attesting witness to speak about it, provided that the executant, the person who is purported to have executed the document, has specifically denied execution of it. This is extremely important. I give an example. A files a suit for declaration of title to an immovable property on the ground that one X, not a party to the suit, executed a gift deed in his favor. Defendant, who is a stranger to the document, denies the execution of the document. The first issue is whether the plaintiff proves that X has executed the gift deed in his favor. X, the donor, enters the witness box and supports the case of the plaintiff and tells that he or she did execute a gift deed. Here, there is no need for the plaintiff to examine the attesting witness because the person who is purported to have executed the document does not deny its execution. Let us take a second case. The case of the plaintiff is that it is the defendant who has executed a gift deed in his favor. The defendant specifically denies the execution of the document. Then there is the requirement of the plaintiff examining an attesting witness in view of Section 68 of the Evidence Act. All this is collateral to the discussion that I am making, but anyway, it's worth making, and therefore I have said it. Then we have the definition of the word register. Register means registered in accordance with the law relating to registration. Then Section 4 is of some relevance. The chapters and sections of this Act which relate to contracts shall be taken as part of the Indian Contract Act. Obviously, because you will find that every one of these sections starts with a subject to a contract to the contrary. You should have a thorough knowledge of the Contract Act also when you deal with the provisions of the Transfer of Property Act. Let us go to Section 5. Section 5 you find in the second chapter, the title, Transfers of Property by Act of Parties. Obviously, it does not refer to transfer by operation of law. It is by act of parties. In the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons, or to himself and one or more other living persons, and to transfer properties to perform such act. That is why we have been told in the law college, transfer of property deals with transfer inter vivos between two living persons. So will is not a transfer. Therefore, you don't find any provision relating to will in the Transfer of Property Act. You will find it in the Indian Succession Act. In this section, living person includes a company or association or body of individuals, whether incorporated or not, but nothing herein contained shall affect any law for the time being in force related to transfer of property to or by companies, associations, or bodies of individuals. Let us go to Section 6. What may be transferred? Section 5, who can transfer? A living person can transfer it to another living person. What may be transferred? Property of any kind may be transferred, except as otherwise provided by this Act or by any other law for the time being in force. The chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of a kinsman, or any other mere possibility of a like nature cannot be transferred. This is that famous spes successionis. I have a son and daughter. They are my class 1 heirs. On my death, each of them would get half share in my property. Neither of them can transfer that half share right now. The chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy. Obviously, because I may during my lifetime gift away the property to someone else, bequeath the property to someone, sell the property to someone, whatever I can do it. They have only a chance of succeeding to my estate. This is the spes successionis. This is prohibited by Section 6 of the Act. I think the other exceptions, let us go to Section 6C. An easement cannot be transferred apart from the dominant heritage. Most of you perhaps may be knowing already that an easement is a right exercised in someone else's property, not on my own property. If I have a right of easement in the property of Mr. X, to enjoy my property, I need the property of X to whitewash my wall, to paint my wall, to get light and air. All these things I am getting from the property of another person. Now, I can't transfer that right of easement alone. It can have to be transferred along with the dominant heritage, that is my own property, is what Section 6C says. Other things I am avoiding for want of time and for want of preparation also. Let me be very honest in this regard. Then let us go to section 7. Every person competent to contract and entitled to transferable property, or authorized to dispose of transferable property not his own, is competent to transfer such property either wholly or in part, and either absolutely or conditionally, in the circumstances, to the extent and in the manner allowed and prescribed by law for the time being in force. So every person competent to contract. That takes us to section 11 of the Contract Act. That is, he who is of sound mind and is not a minor. 8 is also important. What is the effect of the transfer? Unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee all the interest which the transferor is then capable of passing in the property and in the legal incidents thereof. We have heard in courts, lawyers arguing and judges writing. Plaintiff has obtained a sale deed from X. X was not the owner of the property at all, or he was not the absolute owner. The property belonged to Y, or X had only an interest in the property. I can't transfer something beyond what I possess. I can't transfer my knowledge or experience of the transfer of property beyond what I possess. Such incidents include where the property is land, the easements annexed thereto, the rents and profits thereof accruing after the transfer, and all things attached to the earth. When I was studying law, the teacher who taught the law of easements was repeatedly telling the law of easements is an adjunct to the law of property, that is the transfer of property. You will find it here. Such incidents include where the property is land, the easements annexed thereto. You should have a knowledge of the law of easements also when you deal with the law of transfer of property. We have 4 kinds of easements. Easement by grant. Some person allows you to make use of his property, that is grant. Then we have easement of necessity. I will tell you what it is that is relevant in the present context. Then easement by prescription, easement by custom. I will deal with this easement of necessity in the present context here. Such incidents include where the property is land, the easements annexed thereto. There is some misconception prevailing in some quarters about this easement of necessity. Whenever the plaintiff or the defendant in the plaint or the written statement says that the property in dispute is required for him to enjoy light and air, people think it's a case of easement of necessity. No doubt, light and air are necessities. But a mere mention of the word light and air in the pleading does not make it a right of easement. Section 13 of the Easements Act provides for 3 situations when a right of easement by necessity is created. 1 by transfer, the 2nd by partition, the 3rd by will. A and B own 2 properties. Maybe both the properties originally belonged to the same person. Now, to enjoy the property of A, he needs some portion of the property of B. Therefore, he has a right of easement in the property of B. When A transfers his property to C, C also will get a right of easement in the property of B. That is called a right of easement. To enjoy the property, to enjoy the subject matter of transfer, some right of easement in someone else's property is required, that is necessary, and therefore it is called a right of easement. Then there is a partition. Members of a joint family or co-sharers or joint owners divide the property. Now, to enjoy one's share, he necessarily needs to pass through the property allotted to the share of someone else, or enter that property, or make use of that property to some extent. There a right of easement is created, though the property which is required to make use of has not been allotted to his share. He has that right of easement to enjoy the property which is allotted to his share. He necessarily needs to make use of the property allotted to someone else. That is called a right of easement. Third is a case of will. A testator executes a will and bequeaths his property to two or more persons. To enjoy the property bequeathed to particular X, he needs to make use of the property bequeathed to Y. This is called an easement of necessity. Therefore, merely because there is some mention of the word light and air in the plight or the written statement, let us not mechanically conclude that it is a case of easement of necessity. An easement of necessity, I repeat, is created in three situations. One, when there is a transfer. Second, there is a partition. Third, there is a bequest. That is why Section 8 says such incidents include where the property is land, the easements annexed thereto. Now, Section 9 contemplates an oral transfer also. A transfer of property may be made without writing in every case in which a writing is not expressly required by law. A sale of immobile property, the value of which is less than 100 rupees, a lease for a term below 1 year, etc. That could be an oral transfer. Section 10 speaks of condition restraining alienation. Where a property is transferred subject to a condition or limitation, absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property, the condition or limitation is void, except in the case of a lease where the condition is for the benefit of the lessor or those claiming under him. So therefore, there cannot be a restraint on the alienee. This is strictly prohibited by Section 10 of the Act. A word of caution here. If the government makes a grant of a property and imposes a condition that the grantee shall not alienate the property for a fixed term, certainly it does not amount to a restraint on alienation. The statute itself provides for it. Let us be clear about this. Then we will go to Section 14, Rule Against Perpetuity. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer and the minority of some person who shall be in existence at the expiration of that period and to whom, if he attains full age, the interest created is to belong. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living that day. So there cannot be a perpetuation of this. It cannot operate to create an interest which will take time, which will take effect only after the lifetime of one or more persons. This is one thing which may be of some relevance to relevance in the context of examination. Some short question are like this. Please read the commentary on this. Of course, cases are very few these days. Now, I will straight away go to Section 41 of the Transfer of Property Act. Transfer by an ostensible owner. Now, I may also tell you here, Sections 5 to 37 provide for a deal with transfer of both mobile and immobile properties. 38 and onwards deal with transfer of immobile property. I will now take you to Section 41, where with the consent expressed or implied are the persons interested in immobile property. A person is the ostensible owner of such property. He is not the real owner of the property. With the consent expressed or implied of the persons interested in immobile property, transfers the same for consideration. The transfer shall not be voidable on the ground that the transferor was not authorized to make it. This is also a principle of estoppel. So he makes a representation that he has the consent, either expressed or implied, of the person who is the real owner of the property, and he transfers it. the transfer is not voidable on the ground that the transferor, that is the ostensible owner, was not authorized to make it. We have an old decision of the Supreme Court dealing with this concept in some great detail and clarity. You may refer to AER 1952 Supreme Court 207. AER 1952 Supreme Court 207. Musmat Pool Cure. Musamat, of course, party's names, I'll have to give the spelling and all that. It is sufficient if I give the page number and the year in which it is reported. AER 1952 Supreme Court 207. Then another important provision is section 43, which is popularly called as feeding the grant by estoppel. What is this? Where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration, such transfer shall at the option of the transferee operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. The place where I am now sitting is the house of Sri S. Basuraj. I make a representation to one yet saying that I am the owner of this property, make him to believe that I am the owner of the property, sell the property, receive 5 crores from him as consideration for this property. About a week thereafter, Mr. S. Basuraj executes either a sale deed in my favor or a gift deed in my favor. I don't deliver possession of the property to my purchaser. 15 days later, he comes and tells me, you have sold the property to me on 4/4/2022. You have not yet delivered possession. I tell him that as on 4/4/2022, I was not the owner of the property at all. It was Sri S. Basuraj who was the owner. Then he made some inquiries and tells, well, Sri S. Basuraj has executed a gift deed in your favor on 8/4/2022 and has sold the property. You have now become the owner of the property. This is a grant has already been made by me in favor of the X. Some kind of a writing, some document I have executed. Now, the principle of estoppel comes here. I am stopped by the doctrine from contending that I was not the owner. Whatever interest that I have subsequently acquired will have to pass on to him. There is already a grant. That grant is fed by the principle of estoppel. In this regard, we have a very beautiful passage in Mullah's Transfer of Property Act, 12th edition, page 235, synopsis number 3. Mullah's Transfer of Property Act, 12th edition, page 235, synopsis number 3. By the English law of estoppel, where a grantor has purported to grant an interest in land which he did not at the time possess, but subsequently acquires, the benefit of subsequent acquisition goes automatically to the earlier grantee, or as it is usually expressed, feeds the estoppel. The principle is based partly on the common law doctrine of estoppel by deed and partly on the equitable doctrine that a man who has promised more than he can perform must make good his contract when he acquires the power of performance. ನನಗೆ ಸೇರದೇ ಇರತಕ್ಕಂಥ ಆಸ್ತಿನ ನಾನು ಇವತ್ತು ದಿವಸ ಮಾರಾಟ ಮಾಡ್ತೀನಿ. ನನಗೆ ಮಾಲೀಕತ್ವ ಬರ್ತಕ್ಕಂಥದ್ದು ನಾಳೆ. ಇವತ್ತು ನಾನು ನಿಮಗೆ ಮಾರಾಟ ಮಾಡಿದ ದಿವಸ ನಾನು ಮಾಲೀಕನಾಗಿರ್ಲಿಲ್ಲ, ಆದ್ರಿಂದ ನಿಮಗೆ ಮಾಲೀಕತ್ವ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ನಾಳೆ ನಾನು ಪಡ್ಕೊಳ್ತಕ್ಕಂಥ ಮಾಲೀಕತ್ವದ ಆಧಾರದ ಮೇಲೆ ನಿಮಗೆ ನಾನು ಮಾಲೀಕತ್ವವನ್ನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ಇದು this is feeding the grant by estoppel. We have a few important decisions of the Supreme Court which the candidates will kindly read. We have an old decision, AER 1962 Supreme Court 847. The reason why I am citing some old decisions is the foundation is slight. They are all leading decisions. Subsequent decisions have followed them, and therefore I am citing a few old decisions also. AER 1962 Supreme Court 847. This is a decision of 4 judges of the Supreme Court. AER 1962 Supreme Court 847. This is a very famous decision. Jumma Masjid Markera versus Kodi Maniandra Devaya. It is from Kodagu of Karnataka. Jumma Masjid Markera versus Kodi Maniandra Devaya. AER 1962 Supreme Court 847. You may also refer to 1994 SCC 309. 1994 SCC 309. Then 1994 4 SCC 730. 1994 4 SCC 730. 2015 5 SCC 691. 2015 5 SCC 691. 2019 4 SCC 173. 2019 4 SCC 173. The difference between sections 41 and 43 has been explained in 2007 2 SCC 404. 2007 2 SCC 404. For your immediate reference, you may read paras 9 to 15. They explain to you the difference between sections 41 and 43 of the Transfer of Property Act. Now, another important provision which you may refer is section, I will come to section 52 a little later. It requires some explanation. I will go to 53 and then get back to 52 and thereafter 53A. Fraudulent transfer, section 53. Every transfer of immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. Every transfer of immovable property made with intent to defeat or delay the creditors of the transfer. I owe a sum of rupees 5 crores to several persons. If I leave my property as it is, they may file a suit against me, obtain a decree, get my property attached and sold. To avoid that, or either to cause delay in the execution of the decree that may obtain, I sell the property to someone. Such a sale is voidable at the option of the creditor. Nothing in this subsection shall impair the rights of a transferee in good faith and for consideration. If somebody purchases the property from me and he is not aware that I owe a large debt to several persons, he is a transferee in good faith, of course, for consideration also. A bona fide transferee is protected. Nothing in this subsection shall affect any law for the time being in force relating to insolvency. Because insolvency proceedings are proceedings by themselves. There could be a proceeding initiated at the instance of the creditor and also the debtor. Now the Insolvency Act is not in force. We have the Insolvency and Bankruptcy Code. A suit instituted by a creditor, which term includes a decree holder, whether he has or has not applied for execution of his decree to avoid a transfer on the ground that it has been made with intent to defeat or delay the creditors of the transferor, shall be instituted on behalf of or for the benefit of all the creditors. So one person can bring a suit on behalf of all the creditors also. Every transfer of immovable property made without consideration with intent to defeat defraud a subsequent transferee shall be voidable at the option of such transferee. For the purpose of this subsection, no transfer made without consideration shall be deemed to have been made with intent to defraud by reason only that a subsequent transfer for consideration was made. So this principle behind section 53 may be of some relevance for examination. The examinees may kindly go through the commentary in this regard. I will spend some good time on section 52 of the Transfer of Property Act, the principle of lis pendens. there is some mistaken notion among some quarters that when a litigation is pending, that a suit is pending, the subject matter of the suit cannot be transferred at all. That is not the purpose of Section 52 of the Transfer of Property Act. What it says is, such a transfer, lis pendent a transfer pending litigation is subject to the result of the litigation. You will get some indication of it if you read Order 22 Rule 10 CPC. Order 22 Rule 10 CPC says, if there is devolution or transfer or assignment of an interest during the pendency of a suit, the proceedings may be continued against the transferee or the assignee, or it may be continued by him. I'll give an example. A files a suit for declaration of title against B. During the pendency of the suit, B, the defendant, transfers the property to C. A can proceed against C, or C can himself come on record by making an application under Order 22 Rule 10. Supposing A transfers the property to C, then C can come on record in the place of A and continue the suit. This is what is provided by Order 22 Rule 10 CPC. Therefore, the legal position in this regard is transfer itself is not prohibited by Section 52. What it says is it makes the transfer subordinate and subject to the ultimate result of the suit. We have a few important decisions regarding Section 52 of the Transfer of Property Act, because you should know the basics in this regard. AER 1956 Supreme Court 593. This is the famous Nadubai Ammal versus B. Shamrao. Nadubai Ammal versus B. Shamrao. AER 1956 Supreme Court 593. You will read, you will see that two expressions are used in Section 52. During the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, are established beyond such limits by the central government of any suit or proceeding which is not collusive and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding. The difference between a collusive suit and a fraudulent suit has been explained by the Supreme Court in this decision. This is a decision of 3 judges. This is Nadubai Ammal versus B. Shamrao, AER 1956 Supreme Court. See how beautifully the distinction is explained. Now there is a fundamental distinction between a proceeding which is collusive and one which is fraudulent. Collusion in judicial proceedings is a secret arrangement between two persons that the one should institute a suit against the other in order to obtain the decision of a judicial tribunal for some sinister purpose. With a mala fide intention, I do it. I file a suit against X for a declaration of title. X keeps quiet for some time. He just watches the proceeding. When the court is about to place him ex parte, he just appears and says that he would engage a counsel. 15 days later, a counsel would come and file a memo saying that he undertakes to file wakalat for that X during the next date of hearing. On a next date of hearing, he files wakalat, prays time to file written statement. After 2 or 3 adjournments, he files written statement, conceding a decree. Please don't confuse this with Order 12 CPC, judgments on admissions. That is a different thing. Here, the purpose is sinister purpose, a mala fide intention. There is a secret arrangement between them. They say, all right, I file a suit, you give consent. Let us have a decree in respect of a property which does not belong to either of us. In such a proceeding, the claim put forward is fictitious. The contest over it is unreal. And the decree passed thereon is a mere mass having one similitude of judicial determination and worn by the parties with the object of confounding third parties. But when a proceeding is alleged to be fraudulent, what is meant is that the claim made therein is untrue, but the claimant has managed to obtain the verdict of the court in his favor and against his opponent by practicing fraud on the court. Such a proceeding is started with a view to injure the opponent, and there can be no question of its having been initiated as the result of an understanding between the parties. While in collusive proceedings, the combat is a mere sham. In a fraudulent suit, it is real and earnest. See the difference here. Now I told you that Order 22 Rule 10 CPC also gives you an indication that transfer as such is not prohibited by Section 52 of the Transfer of Property Act. It makes it subordinate to the decree of the court. Plaintiff sells the property to a third person during the pendency of the suit. If the plaintiff wins, that the third person gets the property. If the plaintiff loses, he loses it. Similarly, if the defendant sells the property and the defendant wins in the suit, his transferee gets title. If the defendant loses, the transferee does not get anything. In the context of Order 22 Rule 10, we have one decision in AER 1958 Supreme Court 394. AER 1958 Supreme Court 394. Then, Section 52 of the Transfer of Property Act applies to involuntary alienations also, not necessarily to voluntary alienations. This is covered by AER 1967 Supreme Court 1440. AER 1967 Supreme Court 1440. The purchaser pendente lite under this doctrine is bound by the result of the litigation on the principle that since the result must bind the party to it, so must it bind the person deriving his right, title, and interest from him or through him. This principle is well illustrated in an earlier case where the facts were almost similar to those in the instant case. It is true that Section 52, strictly speaking, does not apply to involuntary alienations such as court sales, but it is well established that the principle of lis pendens applies to such alienations also. This has been followed subsequently in 1969, 2 SCC 787. 1969, 2 SCC 787. To have a still deeper knowledge of the provisions of Section 52, its origin, scope, everything, we have one other beautiful judgment in 1972, 2 SCC 200, 1972, 1972, Volume 2, SCC 200. Then one question would arise. The property is sold during the pendency of a suit for partition. The alienee was not impleaded during the pendency of the suit. Can he be impleaded during final decree proceedings has been considered by the Honorable Supreme Court in Khemchand Shankar Chaudhary. I am giving the names of the parties also because it's a famous decision. Khemchand Shankar Chaudhary versus Vishnu Hari Patil. Khemchand Shankar Chaudhary versus Vishnu Hari Patil, reported in 1983, 1 SCC 18, 1983, 1 SCC 18. To prevent further litigation, an alienee pendente lite can be impleaded during final decree proceedings also in a suit for partition. The principle behind Order 22 Rule 10, which also refers to be kept in view when we deal with Section 52 of the Transfer of Property Act, has also been explained in 2001, Volume 6 SCC 534. 2001, Volume 6 SCC 534. The plain language of Rule 10 referred to above does not suggest that leave can be sought by that person alone upon whom the interest has devolved. It simply says that the suit may be continued by the person upon whom such interest has devolved, and this applies in a case where the interest of the plaintiff has devolved. Likewise, in a case where interest of the defendant has devolved, the suit may be continued against such a person upon whom interest has devolved. You may also read for further enlightenment 2005 11 SCC 403. 2005 11 SCC 403. Then with regard to section 52, 2006 1 SCC 148. 2006 1 SCC 148. Let me see whether any put S. The appellants made much of the fact that no leave was obtained from the courts under Order 22 Rule 10 to bring so and so on record as an assignee of their rights. This is an argument which has been raised for the first time before us. The rule gives an assignee of a party's interest in the pendency of the suit the option to apply for leave to continue the suit and is resorted to by an assignee when the assignee is of the opinion that his interest would be better preserved thereby. So it is not obligatory on the part of the assignee to come on record. If he thinks that the plaintiff who has sold the property to him may not prosecute the suit diligently, or the defendant who has sold the property may not contest the suit diligently and properly, he may choose to come on record. Merely because he has not come on record, it cannot be said that the decree doesn't bind him. You may also refer to 2006 3 SCC 608. 2006, I'm sorry, 13 SCC. 2006 13 SCC 608. Some earlier decisions have been referred to, and then it is stated the principles specified in section 52 of the TP Act are in accordance with equity, good conscience, and justice because they rest upon an equitable and just foundation that it will be impossible to bring an action or suit to a successful termination if alienations are permitted to prevail. A transferee pendente lite is bound by the decree just as much as a party to the suit. The principle of lis pendens embodied in section 52 of the TP Act being a principle of public policy, no question of good faith or bona fide arises. So if there is a transfer pendente lite, the transferee pendente lite cannot contend that is a bona fide transferee. I may just digress here for a while. In many suits for partition, there will be alienations pendente lite. If there is an alienation before the filing of the suit, well, the alien can contend that is a bona fide transferee and all that, even that is doubtful. But if there is an alienation during the pendency of the suit, obviously there is no question of saying that he is a bona fide transferee. If during the pendency of a suit property is transferred, and if every transferee contends that he is a bona fide transferee, no suit can be decreed. This is the concept explained in this decision. You may also refer to 2008 7 SCC 144. 2008 7 SCC 144. This decision, apart from referring to section 52 of the TP Act, makes a reference to Order 21 Rule 102 CPC also. If the candidates, either by design or default, have with them the Civil Procedure Code, please go to Order 21 Rule 102 CPC. It's very simple. Now, let me give you an example. In the year 2015, a suit for possession is filed. Suit is decreed in the year 2018. Suit for possession was filed in the year 2015. It was decreed in 2018. During the pendency of the suit in 2017, the defendant sells the property to someone else. In execution proceedings, suit is decreed. When the plaintiff decree holder sues out execution, the purchaser from the defendant cannot maintain an application under Order 21, Rule 97 or Rule 99. A lis pendente transferee cannot maintain an application in view of the clear provisions of Order 21, Rule 102. This decision which I told you refers to the provisions of Section 52 and also Order 21, Rule 102. One more decision with regard to Order 22, Rule 10, which, as I have been repeatedly telling, has to be read along with Section 52, is in 2016, 1 SCC 730. 2016, 1 SCC 730. Under Rule 10 of Order 22, when there has been a devolution of interest during the pendency of a suit, the suit may by leave of the court be continued by or against upon whom such interest has devolved, and this entitles the person who has acquired an interest in the subject matter of the litigation by an assignment or creation or devolution of interest pendent a light or suitor or any other person interested to apply to the court for leave to continue the suit. But it does not follow that it is obligatory upon them to do so. Suit pending ಇದ್ದಾರೆ ಯಾರ್ದಾದ್ರು ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆದರೆ ಯಾರು ಕೊಂಡ್ಕೊಂಡಿರ್ತಾನೋ ಅವನು ತಾನಾಗೆ ಪ್ಲೈಂಟಿಫ್ ಮಾರಾಟ ಮಾಡಿದ್ರೆ ಪ್ಲೈಂಟಿಫ್ ಬದಲಾಗಿ ಕೇಸ್ ನಡೆಸೋದಕ್ಕೆ ಮುಂದೆ ಬರ್ಬೋದು, ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ಇಂದ ಖರೀದಿ ಮಾಡಿದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ ಬದಲಾಗಿ ತಾನು ಬೇಕಾದ್ರೆ ಕೇಸ್ ನಡೆಸ್ತೀನಿ ಅಂತ ಬರ್ಬೋದು. ಆ ಥರ ಬರಲೇಬೇಕು ಅಂತ ನಿಯಮ ಇಲ್ಲ. ಅಲ್ಟಿಮೇಟ್ ಆಗಿ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೋ ಡಿಕ್ರಿ ಆಗುತ್ತೋ ಅದ್ರ ಮೇಲೆ ಅವನ ಸೇಲ್ ಮೇಲೆ ಪರಿಣಾಮ ಬೀಳುತ್ತೆ ವಿನಃ he is not bound to implicate himself. ಅದನ್ನೇ ಎಲ್ಲ ಡಿಸಿಷನ್ಸ್ ಅದೇ ಆಂಗಲ್ ಅಲ್ಲೇ ಹೇಳಿದೆ. Yet another decision under section 52 of the Transfer of Property Act is in 2017 7 SCC 342. 2017 7 SCC 342. Some of the advocates who are now hearing me might have already heard me when I spoke about suits for trial of specific performance in that Beyond Law platform. One Vikas Chatrat is run in that Beyond Law. I have on a few occasions spoken on that platform. Some of the advocates who have now joined might have already heard me on that. I have referred to the judgment of the Supreme Court on that occasion in Thomson Press India versus Non-Art Builders. Thomson Press India versus Non-Art Builders, reported in 2013 5 SCC 397. 2013 5 SCC 397. I have something to say about this decision and the next decision following. Kindly hear me very carefully. Many times, a decision of the Supreme Court in Kasturi versus Ayya Perumal, reported in 2005 6 SCC 733 is cited whenever there is the transfer of the property in a suit for specific performance. But actually in Kasturi's case, that question was not considered. Whether a person who claims an independent title to the property can get himself impleaded in a suit for specific performance. The Honorable Supreme Court said that third persons claiming an independent title to the suit property cannot seek to implead themselves in a suit for specific performance. Thereby, the scope of the suit for specific performance gets enlarged. The only issue is whether the execution of the agreement is proved, whether the plaintiff has established his readiness and willingness, whether time was of the essence of the contract, whether any hardship would be caused to the defendant, and all that. So therefore, there cannot be a further inquiry regarding the title of a third person. But in Thomson Press case, the question was whether a lispendente transferee could be impleaded. That has been specifically gone into. Kasturi's case has also been referred to and distinguished. And by referring to Order 22 Rule 10, the Honorable Supreme Court has said it enables the transferee pendente light to come on record. In fact, the correct provision would be Order 22 Rule 10 and not Order 1 Rule 10. The next decision also requires some explanation. That is AER 2019 Supreme Court 35. As I said, I have already drawn the attention of the advocates who have heard me on a different platform. Gurmeet Singh Bhatia versus Kiran Kant Robinson, AER 2019 Supreme Court 35. In this case, Kasturi has been relied upon. Thomson's Press case was not brought to the notice of the Honorable Supreme Court. But ultimately, the issue boils down to this. Plaintiff being the dominus litis in a suit, he cannot be forced to fight litigation against third persons. Supposing in a suit for specific performance, a transferee pendent allied makes an application under Order 22 Rule 10 to Taman Ratal, and if the plaintiff opposes the application cannot be allowed. On the other hand, if the plaintiff himself makes an application under Order 22 Rule 10 to implead the purchaser, certainly he can be brought on Ratal. So you will have to, this is how you will have to understand Thomson Press and the subsequent decision in AER 2019, Gurmeet Singh Bhatia. We have also a judgment of the Karnataka High Court in ILR 2009 Karnataka 4527 with regard to the applicability of Section 52 in a suit for specific performance. ILR 2009 Karnataka 4527. We have yet another judgment in the context of a suit for partition under Section 52, ILR 2016 Karnataka 2979. These decisions may kindly be read. Now, I will take up Section 53A of the Transfer of Property Act. This is the doctrine of part performance. It is an equitable doctrine. You should know what equity is. I have on earlier occasions told you what equity is. Some advocates might not have joined on that occasion, and therefore for them it is for the first information, for the first time they get to know about this. Day in and day out, arguments are advanced saying specific performance is an equitable relief, injunction is an equitable relief. He has purchased the property, equities may be worked out, and share of the aliener may be allotted to his share and his alienation may be saved. When bail or anticipatory bail is granted by the Sessions Court or by the High Court, an application is moved before the magistrate or the Sessions Court saying that the case may be advanced under Section 309 CRPC in the interest of equity and justice. First of all, 309 CRPC does not provide for advancement. It provides for expeditious trial, day-to-day trial, be that as it may. When decisions are given, a memo is filed saying that these decisions may be taken on record in the interest of equity. What is this equity at all? Mullah specifically, in fact, to tell you that the common law courts were not granting the relief of specific performance. If A had entered into an agreement of sale with B, agreeing to sell the property to him, and if he failed to execute the sale deed, B did not have the option of specific performance. He could only sue A for compensation. Common law courts were awarding only damages or compensation. Then equity, the king, who had the residuary power of judicial administration, used to give the relief of specific performance. Ultimately, there was a merger of the two systems. There were equity courts and common law courts. In India, we do not have equity courts, but there are certain statutory provisions which have recognized this principle of equity. Long back, I heard a learned advocate telling 53A TP Act is Dharma Ayo Papa jurisdiction. This is how he explained the concept of equity. You see, I have given this example on an earlier occasion. I repeat it for the benefit of those who have not heard me on that earlier occasion. You engage a servant maid to work in your house. The salary fixed is 4,500 per month. The understanding is that if she does not turn up for a day's work, then the salary for that day would be deducted. In a month, she does not turn up for 3 days. You act strictly in accordance with the undertaking. You deduct 450 and pay her 4,050. You are in law justified. You are acting according to law. But some of you may be liberal. After all, she is a poor servant maid. Why I should deprive her of 3 days salary or wages? Let me pay the entire 4,500. Some of you may be still more liberal. You may say, all right, she had some problem this month, let me pay her 5,000 rupees. Some others might think, well, I have also a problem. Let me not pay the entire 4,500. Neither shall I deduct 3 days salary. Let me pay 4,200. Those who pay 4,050 deducting 3 days salary are acting in accordance with law. Those who pay anything more than 4,050 are acting in accordance with equity. This is only a rough example that I am giving to you to explain the concept. Recently, I have also been telling, law touches the head, equity touches the heart. This is the concept of equity. Now, as I said, we don't have equity courts in India. Certain statutory provisions have recognized this concept of equity. And one such concept is reflected in section 53A of the Transfer of Property Act. The title is Part Performance. I am also performing my role in part because I have not completed the entire Transfer of Property Act. Part performance, where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding that, where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession other than a right expressly provided by the terms of the contract. What is this part performance then? B agrees to sell his property to A. He also delivers possession of that immovable property to A. A, the purchaser, is ready and willing to pay the balance sale consideration and get the sale deed executed and registered. To use the language of the specific fact, he has been ready and willing to perform his part of the contract. He has taken possession of the property under the document. Or he was already in possession as a tenant earlier and has continued in possession under the agreement of sale. He has done some act in furtherance of the contract. He has paid a part of the consideration. He has put up a structure. If it is a site, he has put up a structure. If it is a house, he has renovated the house. If it is a land, he has cultivated the land. He has put up a pump house. He has done some act in furtherance of the contract. Then the law of equity steps in and says, though you have not become the full owner of the property, though he has not become the full owner of the property, he is entitled to protect his possession. The real owner, the transferor, cannot disturb his possession. This is an equitable doctrine. Earlier, prior to 24/9/2001, this agreement did not require registration. 24/9/2001, Act number 48 of 2001 came into force. It has amended the Transfer of Property Act and also the Registration Act. There is some confusion in the legal fraternity in this regard. Some of them are of the view that whenever possession of an immovable property is delivered under an agreement of sale, that agreement requires registration. kindly go through section 17(1)(a), capital A of the Registration Act. It says for purposes of section 53A of the Transfer of Property Act, it will have no effect. If the document is unregistered, only for the purpose of section 53A of the Transfer of Property Act, it will have no effect. Therefore, to file a suit for injunction and protect one's possession, the agreement of sale requires registration if possession is delivered thereunder. But to file a suit for specific performance, the agreement certainly does not require registration. I am not very sure whether I have brought that decision today. When I spoke on the other platform regarding Registration Act and also suits for specific performance, I have drawn the attention of the audience to a judgment of the Supreme Court in Amir Minhaj, reported in 2018. Kindly check up the citation yourself. Amir Minhaj is a judgment by Honorable Justice Deepak Mishra. And we have got a few judgments of the Karnataka High Court also on the point. In a suit for specific performance, kindly bear in mind, registration of the agreement of sale is not required even if possession is delivered. It is only in a suit for injunction. To protect possession, agreement of sale requires registration. There was one issue here. Now, possession is delivered under the agreement of sale. The purchaser never exhibits his readiness and willingness to perform his part of the contract. He does not file a suit for specific performance in time, but yet continues in possession. Whether the vendor can get back possession was the question. Our full bench of our High Court and the Honorable Supreme Court took the view that even if the period for filing a suit for specific performance has expired, protection under section 53A of the TP Act is still available, provided the purchaser establishes his readiness and willingness. The mere fact that the time for filing a suit for specific performance has expired does not come in the way of the purchaser invoking section 53A of the Transfer of Property Act. This was the view taken by the Karnataka High Court, and also the judgment of the full bench of the Karnataka High Court is in ILR 1998 Karnataka 3230. ILR 1998 Karnataka 3230, Narasimha Shetty versus Padma Shetty. 4 years later, the Honorable Supreme Court in that famous Suryavamshi's case, Suryavamshi versus Suryavamshi, 2002, 3 SCC 676, 2002, 3 SCC 676 took a similar view. I will now give you decisions where this view has been departed from. We have a judgment of our High Court in ILR 2002 Karnataka 3713. ILR 2002 Karnataka 3713. In that case, suit for specific performance had been filed. That suit was dismissed on the ground of limitation. Therefore, the High Court said when the suit was filed after the period of limitation and the suit was also dismissed, it can no longer be said that the plaintiff was ready and willing to perform his part of the contract, and distinguished Suryavamshi's case. This is in ILR 2002 Karnataka 3713. You may also read 2004 8 SCC 614, 2004 8 SCC 613, and then ILR 2009 Karnataka 1534, ILR 2009 Karnataka 1534. Then in ILR 2017 Karnataka 2466, the Honorable High Court remanded the matter to the trial court, saying that it has to consider whether the person who was claiming the benefit of section 53A was ever ready and was always ready and willing to perform his part of the contract. Then, in Vasanti versus Venugopal, reported in 2007, 4 SCC 723, there is a clear departure from Suryavamshi's case, and it is said that unless readiness and willingness is established, the benefit of Section 53 of the TP Act cannot be claimed. To the same effect, we have this Revan Siddhaya's case in 2018, 1 SCC 610. So this legal position may kindly be borne in mind. So important aspect, it is only for purposes of Section 53A, the agreement of sale, if possession is delivered thereunder, requires registration, not for a suit for specific performance. This is something which you need to remember. And one other decision, you may also read, 2018, 7 SCC 646, 2018, 7 SCC 646, Shamnarayan Prasad versus Krishna Prasad. In this case, it is held that the defendant must plead that he has been in possession under the agreement. So whenever benefit under Section 53A is sought, or protection under Section 53A is sought, there must be a specific plea that he has been in possession of the property under the agreement, and then only that protection can be extended. So these are certain provisions with regard to general principles of transfer. Now we will take up a few specific transfers. Sale, as all of you know, if it is in respect of an immobile property worth more than rupees 100, it requires registration. It is not required to be attested by any witnesses. A sale deed does not require attestation. And as per Section 54 of the Transfer of Property Act, a contract of sale, that is an agreement of sale, does not create any interest in the property. This also needs to be borne in mind. Then Section 55 gives a list of the rights and liabilities of the buyer and seller. It's a big list. You will have to read, remember, for purpose of examination, for purposes of practice, as and when a case arises, we can look into it. Nobody can remember all these details. I'm only drawing your attention to the relevant provisions of the TP Act. Section 55 deals with the rights and liabilities of the buyer and seller. Then with regard to mortgage, if the amount secured is more than rupees 100, it doesn't refer to the value of the property as in the case of a sale. If the amount secured is more than rupees 100, a mortgage requires registration. We have 7 kinds of mortgages. One is a simple mortgage. Another is mortgage by conditional sale. Usufructuary mortgage, whereunder possession is delivered or agreed to be delivered. Then English mortgage, mortgage by deposit of title deeds, and anomalous mortgage. Now the chapter related to mortgage is too long. One thing you should remember. A mortgager has got one remedy, that is called the right of redemption. 30 years is the period provided to file a suit for redemption when the right to redeem occurs. For a mortgagee, that is the creditor, he has got 2 remedies. One, to file a suit for sale, and another a suit for foreclosure. You will have to read the provisions of Order 34 CPC in this regard. In fact, if you carefully read the provisions of Order 34, it will be revealed to you that even if the suit is by the mortgagee, that is the creditor for foreclosure, after the preliminary decree is passed, if the mortgager, that is the debtor, pays the decretal amount, then instead of passing a decree for foreclosure in favor of the decree holder, you are passing a decree for redemption in favor of the defendant. So this only goes to show that the law intends to protect the mortgager, because he can get the mortgage redeemed so long as he is willing to pay the mortgage money. no clause on the right of redemption is recognized by law. Law frowns upon a clause on the right of redemption. You have learned in the law college, once a mortgage, always a mortgage, and nothing but a mortgage. Any clause in the mortgage deed which creates a clause on the right of redemption is frowned upon by the court. The court generally leans in favor of the mortgager. That is the principle behind this. Now, I said if the amount secured is more than rupees 100, it requires registration both under the provisions of the Transfer of Property Act and under the provisions of the Registration Act. One exception is in the case of mortgage by deposit of title deeds, it is also called an equitable mortgage. Generally, these financial institutions, banks, KSFC, they resort to this mortgage by deposit of title deeds, where registration is not required. So if the borrower delivers the title deeds to the creditor with an intention that the title deeds, with an intention to create a security on the property covered by the title deeds, then that itself is a mortgage. It does not require registration. But one thing needs to be clarified. If it is a simple memorandum saying that the title deeds mentioned herein are given to you as security for the loan borrowed, then that memorandum does not require registration. If on the other hand, in the memorandum it is stated that today I have borrowed this money, I am offering the property mentioned herein as security for the loan, and I am also depositing the title deeds, then that memorandum itself contains the bargain, contains the transaction of mortgage, and it requires registration. In this regard, we have a beautiful judgment of the Supreme Court in AER 1950 Supreme Court 272, Rajpal Maharaj versus Bhagavan Das Dwaraka, AER 1950 Supreme Court 272. This is a leading decision on the point. The accompanying memorandum itself contains the bargain, contains the transaction. Now, we memorandum ಕೊಡ್ತೀವಿ ಅದರಲ್ಲಿ ಈ ದಿನ ನಾನು ಸಾಲ ತೆಗೆದುಕೊಂಡಿದ್ದೀನಿ, ಈ ಕೆಳಗಡೆ ತೋರಿಸಿರ್ತಕ್ಕಂಥ ಸ್ವತ್ತನ್ನೇ ಆಧಾರ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂದ್ರೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಬೇಕಾಗುತ್ತೆ. ಅಷ್ಟೇ ಬರೆದು ಈ ಮೆಮೊರಾಂಡಮ್ ಜೊತೆಗೆ ನಾನು ಕಲಿಸಿರ್ತಕ್ಕಂಥ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಿದೆ ಟೈಟಲ್ ಡೀಡ್ಸು ಅದು ಸೆಕ್ಯೂರಿಟಿ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಬೇಕಾಗಿಲ್ಲ. So an equitable mortgage or mortgage by deposit of title deeds does not require registration. And a mortgage, as I told you, requires attestation by two attesting witnesses. If it is denied, if the execution of the mortgage deed is denied by the mortgager, then certainly the mortgagee, that is the plaintiff creditor, will have to examine at least one attesting witness to prove the mortgage. Now, in the case of lease, there is one confusion. In the transfer of property, there is apparently there appears to be some conflict between the provisions of the Transfer of Property Act and the Registration Act. Let me read the Transfer of Property Act, Section 107. Leases how made? A lease of immovable property from year to year, or for any term exceeding 1 year, or reserving a yearly rent, can be made only by a registered instrument. Thus far and no further, there is no confusion. A lease of immovable property from year to year, or for any term exceeding 1 year, or reserving a yearly rent, can be made only by a registered instrument. Let me take you to Section 17(1)(d) of the Registration Act. 17(1) small d of the Registration Act. Leases of immovable property from year to year, or for any term exceeding 1 year, or reserving a yearly rent. 17(1)(d) is similar to first para of Section 107. If it is from year to year or a term exceeding 1 year, it requires registration. Para 2 says, para 2 of 107, all other leases of immovable property may be made either by a registered instrument or by oral agreement accompanied by delivery of possession. Therefore, a view was taken by the Honorable High Court of Karnataka. If if the lease transaction is reduced into writing, even if it is for a period less than 1 year, it requires registration going by the second paragraph 107. Right now, I have not brought the citation. The Honorable Supreme Court, somewhere in 1997, has clarified this position. It says a combined reading of Section 107 of the TP Act and the Registration Act would make it clear that if the lease is for a term exceeding 1 year or reserving a yearly rent or from year to year, then only it requires registration. Therefore, it is somewhere in 1997. Kindly go through that judgment. Then we have a provision which deals with the rights and liabilities of the lessor and the lessee. And we have the concept of a tenant holding over. Even after the expiration of the term of lease, a tenant continues. He is said to be a tenant holding over. Obviously, it would be with the consent of the landlord, that is the lessor. Tenant at sufferance, he also continues, but it is a unilateral act without the consent of the lessor. These are certain provisions regarding the lease. Now, exchange I am omitting because the provisions to the sale are applicable to that. Gift. Gift is the transfer of certain existing mobile or immobile property made voluntarily and without consideration by one person called the donor to another called the donee and accepted by or on behalf of the donee. Such acceptance must be made during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. It has to be acceptance during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. Then how will gift is made? For the purpose 123. For the purpose of making a gift of immobile property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. For the purpose of making a gift of movable property, the transfer may be effected either by a registered instrument signed as aforesaid or by delivery. Such delivery may be made in the same way as goods sold or may be delivered. As far as Mohammedans are concerned, we have this hiba, the concept of oral gift. And even if it is reduced to writing, it does not require registration, is the view taken by the Honorable Supreme Court. Then, gift when may be suspended or revoked, 126. The donor and donee may agree that on the happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in part as the case may be. A gift may be revoked in any case in which if it were a contract, it might be rescinded. Such save as aforesaid, a gift cannot be revoked. Actionable claims I am omitting. Well, I am quite conscious of the fact that I have not done justice to the subject. This is for 2 reasons. I was a little busy with my son's marriage and I did not have enough time to come prepared. I referred only to a few provisions of the Transfer of Property Act, mainly speaking from my experience as a trial judge, and of course referring to a few decisions here and there. If the participants have any questions with regard to what I have spoken, it's welcome. Any questions? Any questions? Yes. Any questions, please? Any questions?